The High Court in Pretoria has dismissed this week the National Energy Regulator in Salga's application for leave to appeal an earlier ruling in favour of Afriforum to stop municipal tariff applications for 2024-25 as well as the increases. Now, this might mean that at least 112 municipalities may need to refund end users where increased amounts were charged since July 1st. And there's also the issue of cost of supply studies that also featured prominently in this particular case. Let's speak to energy expert and former Eskom executive Vally Padayachee, who joins us live now for a discussion. Vally, thank you so much for your time this evening. I mean, your reaction to the latest turn of events when it comes to this matter?
Good evening, Bongiwe, and to you and your viewers, and I'm glad to be back on your show, family show. Yes, I think it's now getting this all matter with all the court cases and appeals, etc. In fact, I think there's about 3 court judgments. It's now getting complex and convoluted, and I guess it's also confusing the end-use customer. It's not in their best interest. So we're now in a situation where the municipalities, let's call it the defaulting municipalities in terms of the court, the 112 that you say, may be forced to reimburse the customers that they've been charging the higher tariffs, which, according to the court, should not have been done. So we sit with that situation, Bongiwe.
And there's, of course, Vally, one of the things that Afriforum was raising as a huge issue here, and that is around the cost of supply studies that needed to be done. And we saw at some point that NERSA was giving, a bit of reprieve for these municipalities, but then the court's saying, no, this needs to be done. It's an important step that needs to be done. So municipalities cannot skip this important step. Let's speak about, these studies that need to be done. How important is a cost of supply study?
No, the cost of supply or cost to serve study is absolutely important, not only to a utility like Eskom or the municipalities, because any business, whether a corner shop business, a hawker at the corner of the street, has to know its cost drivers for him to work out his profit margin and his surpluses, etc. So a cost of supply study, cost of serve study is absolutely critical. But I think, in my opinion, the Achilles heel is the different stakeholders seem to be, in my opinion again, interpreting the cost of supply study in different ways. In the context of the EPP and the ERA. So you have NERSA that has a view, you have the municipalities, the different municipalities have a view, you have Eskom that has a view, and I guess the lawyers will have a view. So there needs to be a convergence in terms of that interpretation. And my final point on that is that why the complexity of a cost of supply study is that it's been taken as an absolute, but you can't do that because the ERA and the EPP say that a tariff application needs to start off with a revenue regime being agreed by the regulator and the utility, whether Eskom or municipality, and then the cost of supply study, cost drivers talk to how do you achieve the revenue stream. So not to get too complex. That's where the debate is. But to answer your question, cost to serve, cost of supply study is absolutely critical.
So in light of that then, what you've just described, because you say that these different parties may be interpreting it in a manner in which they themselves understand, in the absence of this convergence of views where we get one singular understanding of what this study is set to be, what is at risk? Because you now have municipalities that may have to reimburse the money, but at the same time, going forward, will they be able to do this if there's still this, the difference in opinion as to what exactly it is?
Okay, that's an excellent question that you've asked me. So let me answer it in a different way, because you've asked quite a few points there. So going forward, the next steps, given this decision by the High Court, both NERSA and Salga, and maybe whoever else, but NERSA and Salga, let's talk about NERSA, can petition the Supreme Court of Appeal, right, the SCA, for leave to appeal. So you petition to leave to appeal. And the Supreme Court of Appeal very quickly could take three decisions. They could agree with the High Court, the lower court, that's one way, and so there's no leave to appeal. They could hear the leave to appeal and then decide that no decision can be made. I'm talking as an engineer, not as a lawyer. And then the third one is that it agrees that there's a possibility of a different decision being taken by the Higher Court, meaning itself, the SCA. So that's a possibility. And then the other fourth scenario, which is a different scenario, is that NERSA could decide not to petition the SCA, but very quickly, if you petition the SCA, then the decision stands down. So in other words, the municipalities could continue to charge the higher tariffs, but that comes with a lot of risks, like what we got now. So my take on that possibility, and I think this is where probably NERSA could be thinking, I don't talk for NERSA, is that they could take this on petition to the SCA, but indicate to the municipalities to cut the losses is that do not continue to charge the new tariffs. In other words, just stay with the tariffs that you had previously, so that in the case of where the SCA hears the case and you fail, then you're not sitting with additional months of overcharging or reimbursement. And then where the complexity is, further complexity, is that the SCA has to consider the three judgments: the Nelson Mandela case judgment, the City Power judgment, the casting judgment, and of course now the Afriforum judgment. So the SCA has to take all those three into consideration, and those three judgments were made by two judges, and those two judges made decisions from different aspects. And my final point on this, I just learned a couple of weeks ago that where you have a NERSA rule, and my understanding is that the EPP, the electricity pricing policy, they're not law. And if a rule is not gazetted, it's not law. So if you are basing your cost of supply study on the EPP policy, doesn't mean that it's not law. So that's the further convolution to this entire quagmire.
Yeah, it really sounds like a quagmire indeed. And as you say, quite a lot for the SCA to consider. But, one wonders then, where does it place the municipalities? Because let's say that, for example, then the court, NERSA says, hold off, should we not get our way here, you may then need to reimburse some of the end users here. And of course, a lot of concern even about municipalities who are coming under huge pressure when it comes to revenue collection. So how does this one play out in that particular regard? Do they then send money back to people? Should they then be ordered to do so? Or how does this payback possibly take shape?
Well, just from a process-wise, and to keep it clean, I would say that the municipalities should wait for, let's call it guidance from NERSA, and this they can work through Salga with the statutory arm, and NERSA, through the NERSA board, has to meet ASAP and make a call on some of the scenarios I mentioned. But importantly, they've got to consider that if they're taking it on petition, should the municipalities continue with the status quo of charging that or not, or advise as to whether they should be reimbursed. So NERSA, in my opinion, is the only body that's mandated to take that call besides the court of law. Bongiwe.
It's going to be an interesting road ahead, and I'm keen to hear your thoughts on what the next step is. Should NERSA and Salga decide, to take this matter further? But Vally, thank you so much for helping us understand just how critical this particular issue is, especially when it comes to issues around electricity and the tariffs as well, of course, as this cost of supply study. That was energy expert and former Eskom executive, Vally Padayachee.